Section 16 of your Rule 110 is about intervention. Intervention of whom? Intervention of the offended party. And according to Section 16, the offended party may intervene by counsel in the prosecution of the criminal offense. The offended party may intervene by counsel in the prosecution of the criminal offense. But when is this possible? Kailan ba ito nangyayari? Answer is, only if there is a civil action instituted together with the criminal action. What civil action are we talking about? The civil action for the recovery of civil liability. So if there is a civil action together with the criminal action that is pursuant to your Rule 111, then that is the time that the offended party can intervene. For sure, some of you did not understand Section 16. So let's explain it. Let's take a look at the case of Dr. Yumol. We all know here who is Dr. Yumol. And according to the Supreme Court, when Dr. Yumol committed that act, he actually offended two entities. The first entity are those si Ateneo Bodyguard, the former mayor, Furigay, and the daughter of the former mayor. So they are the first entity. And the second entity, according to the Supreme Court, is the society in which Dr. Yumol lives in, or the political entity called the state whose law Dr. Yumol has violated. So take note of this, ha? When a person commits a crime, there are actually two entities that he offends, the state and the individual member. And ano ang sabi ng Rule 110 Section 5? We discussed this already. Lahat ng criminal actions, all criminal actions shall be prosecuted under the direction and control of the prosecutor. They shall be prosecuted under the direction and control of the fiscal. Kaya nga sinabi ko doon sa previous video that in a criminal case, ang bida is the fiscal or the public prosecutor. But we said that it is also possible that this individual member happens to be a lawyer or happens to have a relative who is a lawyer. Yung tatay pala is a lawyer, the boyfriend, or any relative. And in fact, in our example, in the case of Dr. Yumol, the daughter of Mayor Rose Furigay, the offended party herself, is a law graduate. And she is not only a regular law graduate, she is an honor student. So in that case, soon she will be a member of the bar. And if you are the offended party, as much as possible, gusto mong mangialam sa iyong sariling criminal case. But can she do that? Because we said that according to Section 5 of your Rule 110, lahat ng criminal cases is under the direction and control of the prosecutor. So, can she make pakialam? Pwede ba siyang manghimasok? Answer is, according to Section 16, she may do so. Because the offended party whose person, whose right, whose honor, chastity, or property has been actually or directly injured or damaged by that criminal act or omission is allowed to intervene. Take note of the word used by the law, it's may. The offended party may intervene by herself or by counsel in the prosecution of the criminal offense. Although the offended party is allowed to intervene, take note that this is not true all the time. This is not true all the time because the offended party is allowed only to intervene in the prosecution of the criminal offense only when there is a civil action. Only when there is a civil action instituted together with the criminal action. So, kailan ba itong nagkakaroon ng civil action? Let's discuss. For you to understand better Section 16, let's take a look at what the law says, ha? According to the law, when a person commits a crime, not only is he criminally liable, but he is also civilly liable. What is our basis? That is your section or article rather, Article 100 of the Revised Penal Code. A person who is criminally liable for a felony is also civilly liable. So, together yan. So, in the case of Dr. Yumol, he is not only criminally liable, but he has also his civil liability. And what is included in the civil liability according to Article 104, that is restitution. Article 104 of the Revised Penal Code, that is restitution. Ito yung if nagnakaw ka, ibabalik mo yung ninakaw mong gamit. Or reparation of the damage caused or indemnification for consequential damages. So dito mo makikita like yung kung may pinatay ka, there would be computation of the life expectancy of the person killed. So one last time, when a person commits a crime, not only is he criminally liable, but he is also civilly liable. So he has his criminal liability, he has his also civil liability. So in a criminal case, when a criminal case is instituted, ano ang sinasabi ng batas? The civil action is instituted together with the criminal action. That is very clear according to your Section 1, Rule 111. When a criminal action or when a criminal case is instituted, the civil action is deemed instituted with the criminal action. What civil action are we talking about? The civil action for the recovery of civil liability arising from the offense charge. So they go hand in hand. Iisa lang ang mga to, criminal action plus civil action. But take note that this is not true all the time. This does not happen all the time, because it is also possible that the criminal action is separated from your civil action. Sineperate ang criminal aspect, sineperate din ang civil aspect. So when does this happen? So this happens, number one, when the offended party waives the civil action. For example, you are the offended party in a criminal case and you saw you realize that the accused has no means, he has no money, kaya nga nagnakaw is because he has no money to buy food. So, you realized, you offended party, that it would be useless to go after the accused for the civil aspect of the criminal case. Useless mag-file, useless mag-claim ng damages, wala ngang pangkain yung tao. So, in that case, you offended party waive the civil aspect or you waive the civil action. Next, when you offended party reserves the right to institute the civil action separately, in a separate case, in a separate court, and at a separate time. During the hearing, you manifested that you do not like that the civil action will go hand in hand with the criminal action. You want to file it in another court kasi gusto mong mas lalong maabala si accused, mas lalong maraming iisipin si accused na cases, and then accused will be stressed out. That is possible. Next, if you instituted ahead of time the civil action prior to the criminal action, therefore, the civil action is no longer together with the criminal action. They are separated. Na-separate na ang civil case. Last, let's add, in cases when there is no offended party, because merong mga kaso na wala talagang offended party, like for example, treason, rebellion, there is no offended party in that case, then what will happen if these 4 cases are available, or if these 4 scenarios rather are availed of by the offended party? In that case, there can be no intervention. Take note ha, pag yung civil action is separated from the criminal action, then there is no intervention that Section 16 is talking about. Bakit? Because again, Section 16 talks only about intervention. Intervention only if the civil action is instituted together with the criminal action. That is what Section 16 is talking about. So if these two are separated, if the criminal action is separated from the civil action, then there can be no intervention. The offended party can no longer intervene by herself or by counsel in the prosecution of the criminal offense, because the requirement of Section 16 is the civil action must be instituted together with the criminal action. This is the meaning again of Section 16. And just to emphasize, no, if intervention happens, if there is an intervention, this one happens, ano ang sinasabi ng batas? Even if there is an intervention, still that intervention is still under the direction and control of the prosecutor. So kahit inallow ka na ni prosecutor, ni fiscal na mag-intervene, mag-initiate, mag-try ng case, but still you are under the direction and control of the prosecutor. Take note of that. Take note that this concept of intervention can also be seen in the civil procedure, and that is your Rule 19. Rule 19 talks about intervention, the entire Rule 19. And kung sa criminal case, it is the offended party who may intervene. In the civil case, in the civil procedure, Section 1 states that the person who may intervene is any person. What is the requirement of the law? The requirement of the law is as long as that person has a legal interest. He has a legal interest in what? In the matter in litigation, in the success of either of the parties, in the interest against both the plaintiff or the defendant, or that person is so situated that he will be adversely affected by the distribution or disposition of the property in the custody of the court or an officer thereof. But ito ang importante sa civil procedure ha, pag pinag-uusapan ang intervention, you need to file leave of court. It must be with leave of court, ang intervention sa civil procedure. Take note also that intervention is subject to the court's discretion, because if the court determines that the intervention will unduly delay or prejudice the adjudication of the rights of the original parties, then they will not allow intervention. Or if the court determines that the intervener's rights may be fully protected in a separate proceeding, then that court has the discretion not to allow the intervention. So take note of the concept of intervention. Meron sa civil, that is your Rule 19, and sa criminal, Section 16 of your Rule 110.